Welcome back to Firepower. In 2026, you don't need to buy a new rifle to become a criminal. In several states, doing absolutely nothing is enough. The rifle sitting legally in your safe today could quietly cross a legal line tomorrow, not because it changed, but because the definition around it did. And most owners have no idea this is coming. That is what makes 2026 different. There is no dramatic federal announcement, no single nationwide ban. Instead, a series of state-level laws, many already passed, are scheduled to activate, expand, or tighten enforcement. These changes don't arrive with sirens. They arrive with deadlines, paperwork, audits, and vague legal language that turns ordinary gun owners into legal liabilities overnight. Today, we are breaking down what is really happening, why it matters, and which states are quietly changing the rules in ways that could seriously impact AR-15 and AK pattern rifle owners. This is not political commentary. This is about awareness, because ignorance does not protect you in court. Let's start by clearing up the biggest misconception. There is no federal assault weapons ban going into effect in 2026. Congress is not passing a sweeping national prohibition. That headline is not real. But that truth has created a dangerous sense of comfort. The real risk is not in Washington, D.C. The real risk is in state legislatures, regulatory agencies, and administrative enforcement mechanisms that operate independently of federal law. State gun laws do not need federal approval to become enforceable. They can restrict ownership, sales, transfers, storage, and use within state borders. And many states have chosen to move quietly, passing laws years in advance, then delaying enforcement to avoid backlash. 2026 is when many of those laws come fully online. To understand why this matters, you need to understand how the term assault weapon is being used. Despite the name, assault weapon does not mean fully automatic. It does not mean machine gun. In most state laws, it is a feature-based or category-based definition. That means a firearm can be classified as an assault weapon based on characteristics like a detachable magazine, a pistol grip, a folding or adjustable stock, a threaded barrel, a flash hider, or even vague standards like being substantially identical to a listed firearm. In other words, the rifle does not need to change. The definition does. Now let's talk about the states where this matters most. First is Rhode Island. Beginning July 1, 2026, Rhode Island will prohibit the manufacture, sale, transfer, and purchase of many firearms classified as assault weapons. If you already own one before that date, you may keep it under a grandfather provision, but that protection is narrower than many people realize. After the deadline, you cannot sell or transfer that firearm to another resident of the state. You cannot gift it to a family member. You cannot pass it down without going through specific legal channels, often involving out-of-state transfers. What looks like permission to keep your rifle is actually a long-term ownership trap that limits your options permanently. Next is Maryland. Maryland already has restrictive gun laws, but in October 2026, the state expands its list of banned firearms to include additional AR and AK variants that previously fell into gray areas. Owners will be given a limited window, roughly 90 days, to take action. That action could mean selling the firearm out of state, transferring it through approved channels, or surrendering it. If you miss that window, possession becomes a felony. This is a pattern you will see repeatedly. Deadlines matter, miss them, and intent does not matter. Colorado takes a different approach. The state is not banning assault weapons outright in 2026. Instead, it introduces a firearm safety eligibility card requirement for certain semi-automatic firearm purchases. To buy, you must complete training, pass background checks and renew eligibility periodically. Existing owners are not immediately affected, but the message is clear. Access is being restricted through process, not prohibition. What is legal to own today may be difficult or impossible to replace tomorrow. Washington State follows a similar path, combining training mandates, storage requirements, and expanded red flag laws. Under these provisions, firearms can be temporarily seized based on perceived risk, even without a criminal conviction. Storage violations can also carry serious penalties. In this environment, compliance is not just about ownership, but about constant adherence to evolving standards. Now let's look at states where assault weapon laws already exist, but 2026 represents a critical enforcement phase. New York is one of them. Under the SAFE Act, many rifles have long been classified as assault weapons, with ownership permitted only if the firearm was registered properly. The problem is that registration compliance is not static. In 2026, the state is increasing audits and enforcement. Failure to update records, errors in registration, or missed communications can result in a firearm being classified as unregistered. That is no longer a paperwork issue. That is a criminal charge. New Jersey presents a similar risk through its use of the term substantially identical. This language allows regulators to expand bans without passing new laws, simply by reinterpreting what qualifies. A rifle that was compliant last year can suddenly fall outside the acceptable definition. Owners are expected to keep up, even when the rules are unclear. Massachusetts is one of the most dangerous states for misunderstanding the law. The state uses a copy or duplicate standard, meaning a firearm does not need to be identical to a banned model to be illegal. Functional similarity can be enough. Even more concerning, grandfathering protections are often unclear or inconsistently applied. Penalties include mandatory jail time, even for first offenses. Connecticut adds another layer through registry audits and storage enforcement. Beginning in April 2026, the state increases verification of assault weapon registrations and requires strict storage compliance. Failure to meet storage standards can result in criminal charges and permanent loss of firearm rights. Again, this is not about misuse. It is about compliance. California rounds out the list with a different kind of warning. In 2026, the state enacts a ban on the sale of pistols deemed machine gun convertible. While this law does not directly target rifles, the logic behind it is concerning. If a firearm can theoretically be modified, it can be restricted. That reasoning has been applied broadly before, and many analysts believe it could expand to rifle platforms in the future. So why is 2026 the turning point? Because these laws are not about sudden bans. They are about gradual enforcement. Registration systems mature, deadlines expire, audits begin, training requirements activate, storage rules tighten. Each step alone seems manageable. Together, they create a legal environment where owning the wrong configuration, missing the wrong form, or misunderstanding a deadline can result in severe consequences. This is not a wave of panic legislation. It is a wave of compliance enforcement. That brings us to the most important part of this discussion. What should owners actually do? First, take inventory. Know exactly what you own, model names, serial numbers, configurations, and any modifications matter. Guessing is not good enough. Second, read your state law directly, not social media summaries, not forum posts. The actual statute or official guidance. Laws change, and misinformation spreads fast. Third, identify deadlines. Many of these laws include specific dates in 2026. Missing a deadline is often what turns legal ownership into a criminal offense. Fourth, review storage requirements. Some states now require safes, locking devices, or specific storage practices. Failure to comply can result in charges even if the firearm itself is legal. Fifth, consider a contingency plan. That might include out-of-state transfers, legal consultation, or re-evaluating where and how firearms are stored and owned. This is not about panic, it is about preparedness. The final message of this video is simple. You do not have to agree with these laws, you do not have to support them, but you do have to live under them if you reside in these states. Courts may challenge them, lawsuits may delay enforcement, but until a judge signs an order stopping them, the law on the books is the law that will be enforced. The most dangerous position in 2026 is not opposition. It is ignorance. If your state is on this list, now is the time to pay attention, not next year, not after a deadline passes. Awareness is not fear, it is responsibility. Let us know in the comments if your state is affected and whether you have already checked your local laws. These conversations help people stay informed and avoid mistakes that cannot be undone. If you want more clear, factual breakdowns like this, without panic and without spin, make sure you are subscribed to Firepower. We focus on reality, not rumors. Stay informed, stay compliant, and we will see you in the next one.